Good morning, good afternoon, and good evening, depending on your time zone. Today we are going to look at how President Tinubu and ECOWAS sanctions on Niger Republic triggers UN sanctions against Nigerian lawlessness, human rights abuses, and the arbitrary detention of Mr. Nnamdi Kanu. Please subscribe, share to your friends and loved ones, and leave your comment. No one on earth could imagine that Nigerian government would judge any nation of the world when it comes to international laws, violations of human rights, and abuse of people's rights. Nigeria is a member and signatory to protocols and instruments of laws of all international organizations like ECOWAS, African Union, and United Nations. This is applicable to Niger Republic. One would ask, what is the role of ECOWAS? ECOWAS' mission is to promote economic integration in all fields of economic activity, particularly industry, transport, telecommunication, energy, agriculture, natural resources, commerce, monetary and financial questions, social and cultural matters. These are the major roles of ECOWAS in this integration of West African countries. However, the coup in Niger Republic exposed how desperate Nigerian government wants to enforce the rule of laws, human rights, and the protection of abusive deposed presidents of West Africa, especially Niger Republic, and the deposed president Mohamed Bazoum. Like Nigeria, Niger Republic is a signatory to all international organizations like ECOWAS, African Union, and the United Nations. However, Nigerian President Alhaji Ahmed Tinubu, the ECOWAS and the Nigerian President are desperate to uphold and police the rule of laws, protocols, and human rights when it comes to West African countries under the control of Britain and France. Following this coup that took place in Niger Republic, the ECOWAS president, who is also Nigerian president, on hearing of this coup, was quick to sanction Niger Republic by cutting electricity and closing borders. Nevertheless, this is a way of reminding the United Nations Human Rights Council and its working group on arbitrary detention, inhuman and degrading treatment that they are weak in protecting and policing protections of human rights and the citizens affected or abused and arbitrarily detained by state parties. This has triggered debate as to what the role of United Nations and its Human Rights Council, ECOWAS President, and its member states are now questioning United Nations Human Rights Council chief and the working group why they have not taken actions or sanctions against Nigeria for ignoring the instructions and the directives on detention of Mr. Nnamdi Kanu since they made their reports known in 2022. Another question is, what are sanctions? Sanctions are defined in various terms, and what it aimed to achieve is a threatened penalty for disobeying a law or rule of law. Sanctions are a form of penalty or restriction imposed by a state or group of states on another state, organization, or individual to coerce individuals or groups to conform to an international agreement or norms of conduct. This is exactly what Nigeria and ECOWAS,
heads of state and government, have decided that this is one coup too many. and resolved that it was time to end the contagion. The situation in the Republic of Niger is particularly unfortunate, as it comes at a time the country is doing comparatively well in terms of security and economic growth. Ladies and gentlemen, the ECOWAS security architecture, which has informed other security arrangements within and outside the region, is anchored on a number of instruments. These include the 1991 ECOWAS Declaration of Political Principles, the revised ECOWAS Treaty of 1993, the 1999 ECOWAS Protocol relating to the mechanism for conflict prevention, management, resolution, peacekeeping, and security, as well as the 2001 Supplementary Protocol on Democracy and Good Governance. The deployment of the ECOWAS standby force is provided for in the 1999 mechanism. Specifically, Article 25 expressly stipulates the conditions for the deployment of such a force. Among other conditions, the article provides that the force can be deployed in the event of an overthrow or an attempted overthrow of a democratically elected government. Furthermore, the Supplementary Act of 2012 also provides for sanctions to be invoked against members that fail to honor their obligations within the community. It also provides for the use of legitimate force in the restoration of constitutional order.
Take many forms, such as trade restrictions, travel bans, asset freeze, and arms embargo. And this is exactly what Nigerian government has done to the Niger Republic junta groups. ECOWAS is using diplomatic tool to express disapproval of certain actions and to encourage compliance with the international laws. They did not accept the change of government through military coup, and they are not accepting violations of international laws and the detention of the deposed president, Mohamed Bazoum. This is also applicable to other West African countries that recently overthrew their democratic governments. Another big question that the juntas within the West African countries are indicting Nigeria for is, why did you not conform to the directives given to you by the United Nations to release the IPOB activist Nnamdi Kanu, and you are policing other countries when you do not conform to the international rules and protocols of the United Nations? This brings us to the detention of Mr. Nnamdi Kanu of indigenous people of Biafra. It is observed that the states within ECOWAS are monitoring what is happening between the IPOB leader Nnamdi Kanu and the Nigerian government. According to Sahara Reporter, in its headline of July 11, 2021, how IPOB leader Nnamdi Kanu was kidnapped from airport parking lot in Kenya. The paper called it illegal abduction of IPOB leader from Kenya and brought to Nigeria. This was confirmed by former Minister of Justice Abubakar Malami on Tuesday, June 29, 2021, that Nnamdi Kanu has been re-arrested At a joint press conference, the State Security Services, also known as Department of State Services DSS in Abuja, Malami said Nnamdi was rearrested and returned to Nigeria on Sunday, June 27th. According to Malami, the IPOB leader was arrested through collaborative efforts of Nigerian intelligence and security services. This triggered investigations and recommendations. The United Nations Human Rights Council referred the case of Kanu's torture to Special Rapporteur on Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment for further consideration. However, according to United Nations Human Rights Working Group on Arbitrary Detention, on July 23, 2022, United Nations Working Group, after thorough investigation, told Nigerian government to unconditionally release and compensate Nnamdi Kanu. The United Nations Human Rights Council Working Group on Arbitrary Detention indicted both Nigeria and the Kenyan governments for arrest and extraordinary rendition, torture, and continued detention of the leader of indigenous people of Biafra IPOB, Mr. Nnamdi Kanu, without due process. In their recommendation, it recommended that government officials responsible for the torture meted to IPOB leader be investigated and punished. The question remains, has Nigerian government investigated those who abducted and renditioned Nnamdi Kanu back to Nigeria? Have they done so as recommended by the United Nations before going to enforce rule of law in Niger Republic? Is this recommendation not part of the rule of law? Is it not part of the protocol they signed that they will conform to the rules and regulations of the United Nations Human Rights Covenant and the protocols? What are they doing in Niger Republic, trying to enforce the same law they do not apply, they do not observe in Nigeria, as recommended by the United Nations, the highest organ body that coordinates and controls the activities of universal human rights declarations and civil and political rights of the citizens of the world. Again, the 16-page report dated July 2022 indicted Nigerian government for contravening the following articles: Articles 2, 3, 6, 7, 8, 9, 10, 11, and 19 of the Universal Declaration of Human Rights against Nnamdi Kanu, and also Articles 2, 9, 13, 14 of his rights, and is arbitrarily and fell within the categories of 1, 2, 3, and 4 of the Covenant and the Protocols. Yet, they are going to Niger Republic to enforce law when do not even listen to the United Nations. How come will Nigeria go to another country to enforce laws they do not observe in their own country? Again, Nigeria do not listen to ECOWAS laws. They ignore them. Many laws, many judgments have been passed against Nigerian government. They have refused to attend to any ECOWAS summons. Then what are they doing in trying to enforce Niger Republic to comply with ECOWAS laws? Since the detention of Nnamdi Kanu in Nigeria, there has been sit at home that has cost the state government in Eastern region billions of naira, of which that falls within the role of ECOWAS It is their duty to promote economic activities, integration in all fields of economic activities. The economic activities of Nigeria has been disrupted due to the detention of Nnamdi Kanu since he was discharged and acquitted by the appeal court. Yet, ECOWAS pretended as if there is nothing happening in Nigeria. But it is their duty to intervene because it disrupts the economic activity of Nigeria and that of Eastern region. ECOWAS has been alive when Boko Haram's Fulani Herdsmen and all the insurgents within the north and northeast that descended into the southern part of the country, people were killed. None of the ECOWAS partners, the president of ECOWAS, the secretary general of ECOWAS, none of them has intervened as part of their duties to ensure that the transport, industrial, natural resources, and commerce are properly protected and the businesses carried out as part of their functions, or monitor and advise the states or countries or nations involved where these insurgents have been disrupting the normal daily activities of the citizens. ECOWAS as a monitoring group was alive when the Nigerian Court of Appeal discharged Nnamdi Kanu. ECOWAS was alive when Sahara Reporter on the May 18, 2023 made its publication, Nigerian government displaying executive lawlessness on Nnamdi Kanu's case, retired appeal judge. A retired Court of Appeal judge, Oludotun Adefope Okoji, had said the detained leader of indigenous people of Biafra was set free from treasonable felony charges preferred against him by Nigerian government because no authority must be allowed to go against its own domestic and international laws. The Court of Appeal, Abuja Division, had in October 2022 discharged Nnamdi Kanu and declared him of the treasonable felony charges preferred against him by the former President Muhammad Buhari-led Nigerian government. The appellate court had agreed with the counsel of IPOB leader Mike Ozekome that Kanu was illegally abducted and extraordinarily renditioned from Kenya to Nigeria against both international and local laws. Speaking, Justice Adefope Okoji, one of the three-member panel of justices of Court of Appeal that set Kanu free of the treasonable felony charges, pointed out that no country or business wanted to invest in Nigeria where judicial disputes took forever to conclude. To show the level of lawlessness, in her conclusion, she stated that the courts must never shy away from calling the executive to order when they resort to acts of executive lawlessness. The duty of the court is to maintain balance between ensuring that the law and the order is obeyed and the protection of individuals from oppressive actions by the executive, unquote. The present government of Tinubu has taken the step of Buhari's regime. They do not comply with the rule of law. They ignore every judgment of the court, and yet they are trying to police the activities of ECOWAS, the rule of law of ECOWAS in Niger Republic or other African countries affected by the current coup waves. It is now the duty of the present government to report back to United Nations and inform them whether Mr. Kanu has been released, and if so, on what date, whether compensation or other reparations have been made to Mr. Kanu, whether an investigation has been conducted into the violations of Kanu's right, and if so, the outcome of the investigations, whether any legislative amendments or changes in practice have been made to harmonize the laws and practices of Kenya and Nigeria with its international obligations in line with the present opinion, whether any other action has been taken to implement the present opinion. These are what Nigerian government needs to do, and also communicate and liaise with the Kenyan government if they are trying to observe and police the West African countries' rules, protocols, and regulations, not ignoring the United Nations, the Nigerian courts, and yet you want to be the police of West African Economic Community countries. Put your house in order before you go to other countries to enforce laws. With this, we come to the end of the program. We thank you once again for tuning in. We ask you to subscribe, share, and hit the notification bell, and we will be happy to welcome your comments. Thank you very much, and God bless you all. Bye.